they ended up taking me to this place that I'm not supposed to be at because of how you and some other judges and other people abuse me in here. And I really don't appreciate being in jail. And I want to let you know that you know for a fact that I'm the one that gave those videos out, and I reported how those babies were getting killed and blood was being spread all over the wall. I mean, you've seen the video. You admitted you did on the other court dates. So what is this, Judge? Are you against me having my own property? Are you against me exposing everybody for killing kids?
All right, we'll see what we've got here with Mr. Sehi. Looks like it's a new domestic case involving Shannon Sehi. I'm not really sure why he would have been allowed to have any contact with her whatsoever, given all of his case history with her. Mr. Sehi, it looks like you're back in jail on new charges. There's some of the same similar.
Judge?
Yep.
Born on the record, I reserve all my rights under the Uniform Commercial Code, specifically UCC 1-308.
Okay, I'll note that. I'm going to quickly go over the charges with you. You should receive a copy of them and you can just read them yourself. But count one, you're charged with threatening Shannon Sehi on or about the 23rd day of April, 2025 in Butler County, Kansas.
That never happened.
They've not communicated what the exact threat is, but they've alleged that you threatened to commit violence or communicated with her with the intent to place her in imminent or immediate fear.
That's not true.
Okay, so I'm going to enter not guilty. If convicted, 5 months up to 17 months with the Department of Corrections, up to $100,000 fine. Has to run.
Judge, since this is the first court date, I would like the evidence to be presented for it on the record.
Okay, so what happens is, and I don't want to read it out loud, but the judge assigned will get an affidavit. Well, yep, I'm assigned. I will get a probable cause affidavit for this arrest. And if there is probable cause, which is something more than a mere possibility that a crime was committed and you may have committed said crime, then I approve the arrest. But then I go ahead and get your case set for preliminary hearings so that you can have actual evidence with representation, if you want it, for a probable cause finding with
Judge. But I'm not playing anything because, first of all, I was on my own property at my own house, and I had to explain to somebody that she has no jurisdiction in what I do over my house, or even in my house or on the property or whatever. And she called the police on me, and then the police came on my property and said, I don't know what you're here for, but with all due respect, I don't want you on my property. And then they said that, well, we got a call that said that you were being violent and that you were threatening. I said, well, that never happened, and you don't have to talk to me. You can talk to her. And so anyway, they ended up coming up on the porch, and I opened the door again. I said, I don't want you on my porch. And they said, well, we need to talk to you. We need to find out, you know. And I said, well, I don't know what you're talking about. I'm not violent. Wasn't violent at all. And so he said, well, she wants her keys. And so I said, oh, well, I mean, okay. Well, so I gave him the keys. So I gave that dude the keys so she could have them, but she could have came in and got the keys anytime she wanted to because there are no threats. So anyway, the police officers, after I gave him the keys, he opened the door and said, well, now I'm going to have to arrest you. He said, you're under arrest for threatening. And I said, I don't know what you're talking about. So I closed the door and I went the opposite direction. This dude kicked in the door and shot me in my back with a taser that burnt my back. Do that again, Judge. Do that one more time. Put the pen to the camera like you did. Did you switch something?
Nah, Mr. Sehi, I did not. Mr. Sehi.
Okay, well, anyway, that's what it is. And they ended up taken me to this place that I'm not supposed to be at because of how you and other judges and other people abuse me in here. And I really appreciate being in jail. And I want to let you know that you know for a fact that I'm the one that gave those videos out, and I reported how those babies were getting killed and blood was being spread all over the wall. I mean, you've seen the video. You admitted you did on the other court dates. So what is this, Judge? Are you against me having my own property? Are you against me exposing everybody for killing kids? For and on the record.
Mr. Sehi, all I'm doing today is
Please stop moving your hand to the camera. You're doing that intentionally.
No,
stop doing that.
No,
you were told that I'm not
Mr.
supposed to be in this jail. You know for a fact I'm not supposed to be here. Where's the evidence at?
Okay.
For and on the record.
Turn off the audio. Now. Mr. Sehi, in count 2, you're charged with battery against a law enforcement officer, a Class A person misdemeanor. If convicted, it's a maximum of 6 months, $1,000 fine. In count 3, you're charged with interference with the law enforcement officer, resisting arrest. If convicted, it's a level 9 non-person felony. In count 4, you're charged with threatening a police officer, Cody Marvin. It is charged by the prosecutor's office as criminal threat, a level 9 person felony. If convicted, you could receive 5 months up to 17 months with the Department of Corrections, up to $100,000 fine. I imagine count 2 through 4 are incidents that are caught on camera, as most of the officers wear body cams. Probably not count 1. That will have to be the statements of Shannon Sehi as to any reporting of any threatening statements by you or actions by you. I'm going to enter not guilty pleas on all of the charges. I'm going to schedule this case for an immediate preliminary hearing at the first available date I have, as well as I'm going to review the probable cause affidavit that should be submitted by today by the prosecutor's office for e-filing, so that I can determine whether or not they had probable cause for an arrest, and then give you a full hearing on May the 28th at 10 a.m. Now I'm going to set bond for you, and I'm going to ask for a recommendation from the state.
Yes, Your Honor, and the state is recommending a high bond in this case, as may be determined by the court. As part of special conditions, the state would be recommending no contact with any endorsed witnesses or alleged victims, that the defendant can take prescription medication and no drugs or alcohol. I believe the court has already indicated some familiarity with the defendant on the record here today. Additionally, this appears to be a defendant with a history of adjudications and convictions the court may consider relevant. Disorderly conduct and at least 2 battery against the school employee adjudications, as well as convictions for disorderly conduct, misdemeanor assault, domestic battery, criminal restraint, and felony interference with law enforcement. Pursuant to the affidavit, this appears to be a defendant who attempted to barricade himself within a residence, as well as threatened to kill multiple individuals, including at least 1 law enforcement officer. And it would also appear that there is another Butler County case, Butler County 21 CR 457, which does appear to involve a journal entry of judgment of direct contempt of court signed by Chief Judge Rickey. And in that case, it would appear that the defendant was convicted of battery, in which the victim was a detention deputy.
Okay. I'm sorry, what was the amount that you're recommending?
Your Honor, the state is prepared to defer to the court as to an appropriate amount. Certainly, the state would not be opposed to a $7,500 cash or surety bond. However, given the particular facts and the history of this defendant, the state does respectfully suggest a much higher bond is appropriate.
Okay, well, I'm gonna set his bond at 10,000 cash or surety with GPS. Absolutely no contact whatsoever, with, Ms. Sehi. And I assume she still has his child, but I don't know. I'm actually surprised if they were in contact or living together. If he had remained, attentive and didn't leave the room here this afternoon, I would have asked him for any statements he wanted to make about bond. And I probably would have asked him about his living situation, and any potential no contact orders with Shannon Sehi. I'm going to assume, since he's not charged with violating a no contact order of any kind, that they were allowed to resume cohabitating, either as he flattened his time or his probation expired or someone lifted no contacts. It's been a while since I've had any cases with Mr. Sehi. My cases with him were disposed of rather quickly. But at any rate, that's the bond. I gave him an expedited, this is actually a preliminary hearing, not a control setting. I don't know if Mr. Watts will have a conflict with representing him. It seems like maybe Mr. Favre has been his attorney previously. So
And
if Mr. Watts does, he can forward the case to Mr. Favre.
And Your Honor, what I would tell the court is that journal entry of sentencing in Butler County 21 CR 457, it would appear that that journal entry does make reference to Mr. Favre, and in response to the court's earlier inquiry, it would appear that the court did order 6 months in jail, but that the defendant was awarded credit for time served.
Okay, so essentially flattened his sentence. Yeah. Okay. Now, these preliminary hearings are in person. So he's to appear in person, and at least he won't be aggravated with my pen because he won't be able to see anything in my hand in the courtroom when I'm on the bench. But historically, he's failed to come out of his cell. And I don't know if he has a history of failing to appear if he makes bond, but we will deal with that if and when it happens. But this is, as I indicated, evidentiary hearing with witnesses in my courtroom. We are adjourned.